What happened in the Shatta Wale MOG case? Hello guys, and welcome to another episode of Blues Law. I know that in the last video I told you guys that we're going to talk about the Bravo and Drake issue, but obviously there has been another issue which demands our urgent attention, so I'm going to make this video about that issue. It's the issue of MOG and Shatta Wale and sale of someone's catalog. To begin this, I'll remind you guys to watch my previous video on master rights and publishing rights and generally copyright in music. If you watch that video, you understand this video better. Let me start by talking about contributors to a composition or ownership of master rights. Every contributor to a composition or an owner of master rights is entitled to payment. Simpliciter. Anytime there are multiple contributors to a work, everyone is presumed to own equal shares of the work unless there is contrary evidence. Contrary evidence here is a contract. We will talk about the payments. A payment could be credit, one-off fee, or royalties. Depending on your negotiation skills, you can get one, any of the two, or all three. Totally depends on you. I don't like mentioning standard percentages or standard fees because someone might use my words for something is not intended for. So we'll stick to agreements. People are free to enter into any agreement at all. You can even give up all your rights. You can say you don't want any payment as long as you sign an agreement to that effect. Now, under our laws, a contributor to a work cannot by mouth or verbally say that they've given up the work. There must be evidence of same. So the law is here to protect contributors to a work. Basically, that's it. So if, let's say my name is Diamond, I am a producer, I make beats. I've made a beat and I have a signature on the beat. When you hear the beat, there's something they say, maybe Diamond on the beat. There's a beat with Diamond on the beat. Diamond on the beat is simpliciter evidence of contribution by me to the song. So I make a beat for an artist, let's say Kojo. Kojo is an artist. Diamond on the beat is a producer. Diamond on the beat makes a beat for Kojo and Kojo sings on the beat. Now the song is dropped. Diamond on the beat doesn't see his name credited as a producer. Diamond on the beat doesn't get any payment for the beat. Now Diamond on the beat complains about this. If Diamond on the beat complains about this, on the face of it, he has a case because when you play the song, you hear his signature, Diamond on the beat. Do you understand? You hear his signature on the beat, so automatically it's presumed that he is a contributor. Now for Kojo to prove otherwise, that Diamond on the beat is not entitled to royalties, he has to show that Diamond on the beat signed a contract, a written contract. Our laws does not allow oral contract. It should be written. A written contract to show that Diamond on the beat gave up all rights to the beat, including royalties and right to be paid. Unless Kojo does that, Diamond on the beat is entitled to payment for the beat. In music, there are a lot of contracts. There are different kinds of agreements people sign. People sign licensing agreements, people sign recording agreements, recording contracts, acquisition contracts, service contracts, and all that. All these contracts have their own implications and their terms depending on what people negotiate actually. But on the face of it, a 360 deal, we all know. You sign away your rights to a label to exploit it, use it for some time, own all the masters in it. They don't need your authorization for anything. After some time, it may or may not revert back to you. When it comes to licensing, you give someone permission to exploit your work. They make some money and they bring you a percentage of it and keep a percentage. Some even take a fee and bring you the money from exploiting the masters. Now an acquisition contract is signed to acquire catalogs. Acquisition contracts are signed after the songs have been dropped and have gained value over a period of time. The company offering to buy the catalog is supposed to conduct their own due diligence, and this due diligence involves checking to see if actually the person you are buying it from is the actual holder of those rights, number one. Number two, they also evaluate and value the work. They check the streams it has acquired, the brand of the artist, the value, the future value, the past, the present value of the catalog. And they use everyone uses their own metrics for that. So there is no set price for selling music catalog. It's all based on your negotiations. The numbers and everything matter. What happened in the Shatta Wale MOG case? Everything said in this video is alleged because we've not seen anything. Personally, I've not seen the contract that Shatta Wale signed. Everything I know is from the timeline, Twitter and MOG and Shatta Wale's interactions. From what we know, from what's in the grapevine, Shatta Wale sold his catalog to a company, and he represented to the company that he owned all the rights in all the songs he sold. Now MOG is saying that he produced some songs on it, and on the face of it, when you listen to those songs, you hear MOG baby. That's evidence on the face of it that he contributed to the work. As stated earlier, if you contribute to a work, you're supposed to be what? Paid for the work. Did they have a contract? Apparently, no, they did not. But remember, I stated earlier, not having contract does not inure to the benefit of the artist, but rather it inures to the benefit of the contributor who is being denied payment. Because if he can prove that he contributed, then he's entitled to pay. Unless the artist can show. So unless Shatta Wale can show that MOG signed an agreement, he can show that agreement where MOG gave up the rights in these songs, then to me, I think MOG has a strong case. Unless Shatta Wale can show evidence of MOG giving up those rights, the rights to be paid. There was a tweet where Shatta Wale said he took care of MOG's mom's medical bills and paid for the studio and all that. It makes a lot of sense if they agreed that that was going to be the payment for MOG's work. And that agreement must have been in writing. In fact, evidence of that agreement would have been okay. But to date, we've not seen any such evidence. The last question someone asked me was, does this mean that MOG has won the case? There is no case yet. The takedown is just for the DSPs and the distributors or whoever is distributing the songs to ascertain whether he has a good case or not. And since he has been able to prove that he was actually the one who made those beats, Shatta Wale has to go and respond and put forth his case. If he wins, or if they come to the conclusion that he has a case, then they will put the songs back up. Now, the main reason why this is an issue is because, remember in my other video, I stated that every contributor's consent must be sought before transferring any right to someone. Once there are contributors to a song, one of the contributors cannot sell it or make money off it without giving them a share of it. So if everything in the public domain is accurate, then it means Shatta Wale has taken money that's meant for himself and other producers or other songwriters that I'm not aware of without giving them their share. And that is why this case has come into the public domain. I'm very grateful that people keep doing these things so that we can get something to talk about and teach people. I have a longer version of this video on my YouTube, Efia Blue. If you have any questions, you can drop it in my comment section or you can send me a DM. Thank you.